To help walk us through all of this, our defense attorney Misty Marris and New York Times journalist and CNN contributor Lulu Garcia Navarro. Misty, first, what more does this leaked document tell us about this Idaho case at this point?
What we've seen from the leaked document is that the court is going to say that the review by the Supreme Court was what's called improvidently granted, meaning the Supreme Court took the issue on too soon. And so what's going to happen is in Idaho, where there's a very, very strict abortion law that says abortions can only be done in emergency situations if the mother's life is at risk. So that put doctors in a real conundrum. It was a huge problem because what if something was a serious health concern and an abortion would have resolved that? Well, that could put them in a position where they would face criminal liability. So this is all part of the Biden administration's argument. But the argument was bigger than just this law. It was about a federal emergency care law, which, if the Supreme Court adopted, would have said that these laws across the country have to be extinguished, that medical care needs to be given not just when a mother's life is at risk, but when there is risk of a serious medical condition. This draft opinion, what was posted yesterday, seems to fall short of actually addressing that key issue. So it seems that, as you said last hour, it's more of a kick the can, and that more cases will come to the Supreme Court with different factual scenarios. And at some point, these issues will have to be addressed because medical providers don't know what the line is in states where these laws are so limited with abortion rights.
I'm hearing, thank you, Misty, I'm hearing that we have got an opinion on Purdue Pharma. This is Harrington versus Purdue Pharma. Many of our viewers will be familiar with Purdue, obviously associated with the opioid crisis. What have we got? And I know this is difficult because you're just reading as I go to you live. What are we seeing here?
So I'm opening up the decision right now. Keep in mind, this case is about an agreement whereby there was a bankruptcy, and it's about whether or not this bankruptcy setup is constitutional under the law. So I am pulling the decision right now to see where it came out. This relates to opioid victims who overdose with Oxycontin drug produced by their company. And so obviously the opioid crisis in the United States and across the world is a big issue.
Misty, as you look at this ruling, and as you're going through it, I know in real time as well, the fact that the Sackler family is now, as Jessica just pointed out, will be potentially, perhaps expectedly, getting more of these lawsuits. What does it mean moving forward? The fact that the justices did reject this, does it impact on a broader level bankruptcy or other attempts, similar attempts potentially in this country to shield oneself?
Absolutely. It's actually going to directly impact another setup, which was very, very similar to the Purdue Pharma, although the subject matter was much different. So Purdue Pharma was, as was set forth just so perfectly, set up, basically it was a fund. And that money was going to go to states, governments, but also it was going to go to those who were bringing claims regarding opioids against that family. And so that amount of money was going to serve as what we'll call colloquially settlements, right? It was going to be payouts relating to those claims. Now they're not immune to those lawsuits. Very, very similarly, the Boy Scouts of America actually has a very similar statutory setup where there is a bankruptcy proceeding, and the victims who made claims against the Boy Scouts of America are going through that proceeding. So it's not really just in isolation that this was something that Purdue Pharma was using to resolve these claims, to resolve litigation, and to keep their damages basically capped at whatever that amount of money was. It's also going to impact other similar statutory schemes that have gone through the bankruptcy courts. So it's going to have a much broader impact. That's one of the situations where a similar setup has been done by the bankruptcy court. But now that bankruptcy proceeding is not going to shield litigation and liability and damages in these types of cases. So it's actually a really big ruling.
a really big ruling. There also is the broader impact of just the opioid crisis in this country and what for many Purdue Pharma came to represent. This is something that was a big deal on the campaign trail back in 2020. We cannot avoid the fact, right? There is an important debate tonight. We are nearing a presidential election, and addiction in this country is still a major issue, and all the fallout from it, much of that economic in a number of cases. On a broader level, from a society perspective, this is also a really important ruling, Lulu.
It's huge from a society perspective, and it also opens up the doors for different levels of accountability and different legal theories to actually proceed.
We also did have an earlier ruling today, the first opinion that dropped, that was about, and I'm just going through my notes here, but this was in Ohio versus the EPA. Not much of a surprise given what we have seen and continue to see out of this very conservative Supreme Court.
Not much of a surprise at all. In addition to that, the Supreme Court has been very skeptical and has been in many of the cases that we've seen so far this term, really limiting that federal agency power. So while this case didn't necessarily go there, it relates only to the emergency petition and what can be in place during that time frame while the litigation plays out. We know that in several other cases, and one involving the SEC that we might see today, that the Supreme Court has been very skeptical of federal regulatory authority of agencies like the EPA. So that makes this even less surprising than even just the merits of the case and the underlying issue.